Welcome to the second program of Access for All. I am your host, Robert Gorski, and for over 2 decades, I have discussed and helped to implement the Americans with Disabilities Act in Pasadena. In today's and in coming programs, I will talk with you about the ADA, what it is, and how it is making our community more open and accessible to people with disabilities. The programs will be interesting, enlightening, and even a little fun. To help me do my job, I have documents and graphics to share with you, and I have Wheelchair Boy to give me occasional advice. In addition, here is the Stone of Truth, which will help to resolve complexities in the ADA. It comes from a secret cave in the state of Utah. By the way, an accessible cave. In today's program, we are going to focus on how the ADA protects people with disabilities from discrimination in employment. Let's take a look at a graphic that was used in the first program, showing the different areas of community life covered by the ADA. As I mentioned in the previous show, there are 5 areas of coverage, and they can be associated with the 5 fingers of a hand. The first part of the ADA coverage is called Title I employment, and it is aptly associated with the first digit of the hand, the thumb, which does a lot of work. Employment discrimination based on race, gender, nationality, or religion has been recognized in this country for many decades. Employment discrimination based on disability is a recent new concept, and for a long time, it was not perceived as something to be avoided. Many people thought it was natural that individuals with disabilities could not work or were only able to work a little. Also, it was a widely accepted belief that having a disabled person in the workplace would create problems. For instance, many years before the ADA, I applied for my first job, residence advisor at my college dormitory. At the end of an interview with 3 people that went well, the first interviewer looked down at his feet and said, "Well, I don't know. We have never hired a disabled person before, and I am worried about what it will mean to our insurance." The second interviewer was silent. Fortunately for me, the third interviewer was very enthusiastic about trying something new and thought that the insurance issue would not be a big problem. I got the job. By the way, the issue of insurance, rates going up, is nothing but a cobweb. Ratings go up because of on-the-job accidents, not because someone is hired who has arthritis or uses a wheelchair. I have another example about discrimination in employment based on disability that Title I makes illegal. A woman who uses crutches submitted her resume and credentials for a job, and then she received by telephone an invitation for an interview. But when just before the interview began, the interviewer stated, "I wish you had called me over the phone and told me that you had a disability. I could have saved you the trouble of coming here." The woman did not get the job. In both cases, an interviewer considered an unsubstantiated evidence that the applicant was not qualified for the position, and with this disability would bring problems to the workplace. In a nutshell, That kind of discrimination is illegal under Title I of the ADA. In today's program, in order to explain in more detail what an employer must do to avoid illegal discrimination, I'm going to mention several terms that may be unfamiliar to you, but they are very important. Here are the 5 terms. Reasonable accommodation, essential job functions, interactive process, direct threat of significant harm. I will describe them as we go along, but the last and most critical term to understand is the ADA definition of disability. Now, I'm going to approach the ADA definition by first going back to one of the subjects of the previous show in this series, accessible parking spaces. I talked about the most important features of an accessible parking space, but I purposely did not talk about who is eligible to park there. And for many people, this is an issue that sparks frustration and righteous anger when they see someone getting out of a car in an accessible space who does not appear to have a disability. Moreover, we have all heard news stories about non-disabled people who use a relative's disability placard or buy one illegally on the black market. But the situation is not as simple as it seems. Here is a graphic showing a person in shorts, running shoes, and a number on their back getting out of a car parked in a space designated as accessible. Now, a driver may be transporting a person with a disability who has a placard and can see and can use it in any vehicle. And again, there are some disabilities which do not manifest themselves visibly, but still limit a person's ability to walk long distances and to climb stairs. An example is multiple sclerosis, whose debilitating effects can be very intermittent and are often exacerbated by warm weather. Now, here's the real kicker. The ADA does not determine who can park in an accessible space. That is left up to the states. Fortunately, there is a written into the definition of disability among the states, the principle of reciprocity, which allows a person who has a disability placard issued in one state to be deemed eligible to use accessible parking in all other states. Yet, it is vital to understand that the ADA does have a definition of disability that is the basis for the definitions of disability and eligibility used in the states. And furthermore, it is used for all the protections against discrimination covered in the ADA. And it is very important to keep in mind, the ADA definition is a civil rights definition, and it may differ from definitions used in other circumstances. For example, here is a graphic showing a number of different other programs that have different definitions of disability. First, supplemental security income. It's a Social Security program. Eligibility factors include such things as age, education, and work history. State rehabilitation programs may cover some conditions and impairments not covered by the ADA. Veterans programs include as factors the length of military service and the type. A baseball team's disabled list, something that we see often and hear in the papers and read often and hear often on television, typically covers temporary injuries and injuries that often only affect one very specialized work activity, such as the ability to throw a good sinker pitch at 90 miles an hour. Workers' compensation and private insurance, those are other programs that have definitions of disability that can differ. Each of these programs define disability a little differently from the ADA. And in fact, even within the ADA, there is one area of coverage where the definition of disability is a little different from the definition in the other areas of coverage. That area is employment. Now let's turn to the general ADA definition of an individual with a disability. And after that, how that definition is modified by Title I of the ADA, which covers discrimination in employment based upon disability. That's Title I. Now, the general definition, under all titles of the ADA, an individual with a disability is a person who has, 1, a physical or mental impairment that substantially restricts or interferes with a major bodily function or a major life activity, such as hearing, seeing, speaking, breathing, performing manual tasks, walking, caring for oneself, learning, working. And 2, the second part, and notice it begins with or, not an and, number 2, or a record of such an impairment. An example of that is someone who has had cancer treated successfully. They may have a record of being impaired, but they aren't impaired at that time because the treatment has been successful. And in the past, some employers have used that record as an excuse to say, oh no, you're not going to work here. Now the person doesn't have a disability, but they have a record of disability. Now the third part of the definition is or is regarded as having an impairment. An example of this is facial disfigurement or epilepsy controlled by medication. Because the 3 parts of the definition are often referred to as prongs, I am using a graphic of a fork with 3 prongs to illustrate the definition. Now, one exception to this ADA definition is a temporary impairment that is not severe. Such an impairment is not justified as a disability under the ADA. Now, a second exemption. There is a short list of several conditions which specifically are not protected by the ADA. For example, pyromania, kleptomania, and there are several others of a similar nature. Now, while these conditions may be covered by other federal laws or state laws, which protect individuals against discrimination based on those conditions, but these conditions are not covered by the ADA. Now it is time to look at Title I. It does not protect every individual that meets the general definition of an individual with a disability. This is because Title I has a very important addition to the ADA general definition. Let's look at a different fork with 4 prongs. As in the previous graphic, you see the fork, but this one has 4 prongs, and the 4th prong is labeled qualified. Only Title I has this addition to the ADA general definition of an individual with a disability. To be protected by the provisions of Title I, the individual must be qualified for the job he or she holds or is trying to get. If the individual is not qualified, then they are not covered. What does qualified mean? It means two things. First, the individual meets the job requirements for educational background, employment experience, skills, licenses, or any other qualification standards that are job-related. Second, the individual is able to perform the essential tasks of the job with or without reasonable accommodation. Now, in the remainder of this program, I'm going to proceed in a question and answer format and provide the answers after giving you, the viewer, a moment to think. Because the questions I ask are sometimes subtle, and the answers may not seem credible to some viewers, I will have recourse to the stone of truth to verify the answers as correct. If the stone heats up, that means the correct answer is yes. And if the stone remains cold, the answer is no. Here we go with the first set of 3 questions. Question number 1. Are all employers covered by Title I of the ADA? Okay. Now, the answer is yes. Obviously, of course it is. The ADA is a law for the entire nation. But wait, the stone is cold. Let me check my notes here. Well, the stone is correct. The answer is no. Now, while Title I covers many employers, it does not cover them all. It does cover, let me get my notes out here so I can read them correctly. It does cover private employers, state and local governments, employment agencies, labor organizations, and labor management committees, but it only covers those entities which have 15 or more employees. Now, between 1991, when the ADA became law, and July 26, 1994, the threshold number was 25 employees, but today it is 15 employees. Another important employer who is not covered is the federal government, because it's covered by a different law. Okay, let's move to question number 2. Is hiring the only employer activity covered by the ADA? The answer is, the stone is cold, the answer is no. All employer activities are covered, not just hiring. It is unlawful to discriminate based on disability in such activities as recruiting, application forms, paying, hiring, firing, promoting, job assignment, training, leave policy, layoff practices, benefits, everything. Everything that an employer does is covered by Title I. Let's move to question 3. If I have several qualified applicants for a job, does the ADA require that I hire the applicant with a disability? Now, I would like to say yes, but the stone says no. You may hire the most qualified applicant. The ADA only makes it unlawful for you to discriminate against a qualified individual with a disability based on that disability. Don't make your employer decisions based upon a label. The ADA does not interfere with an employer's right to hire the best qualified applicant, nor does the ADA impose any affirmative action obligations. The ADA, Title I, simply prohibits you from discriminating against a qualified applicant or employee based on his or her disability, or, as we found out earlier, a record of having a disability, or being regarded as having a disability. Let's move to question number 4. Okay, got my hand on the stone here. One of my employees takes insulin daily to control diabetes, and the diabetes has no significant impact on the employment. Is she protected by the ADA? Okay, the stone is heating up. It says the answer is yes. The determination as to whether a person has a disability under the ADA is made without regard to medications, auxiliary aids, and reasonable accommodation. If an employee has an impairment that substantially limits a major life activity, she is protected under the ADA, regardless of the fact that the disease or condition or its effects may be corrected or controlled. Question number 5. While a worker's broken arm heals in 2 months, he is unable to perform the essential functions of his job. Is this employee protected by the ADA? Stone is cold. The answer is no. Although this employee does have an impairment, it does not substantially limit a major life activity, or it is of a limited duration and will have no long-term effect. Question number 6. Under the ADA, can an employer refuse to hire an individual or fire a current employee who uses drugs illegally? Stone is hot. Yes. Individuals who currently use drugs illegally are specifically excluded from Title I's protections. However, the ADA does not exclude persons who have successfully completed or are currently involved in a rehabilitation program. I emphasize currently involved. That person is covered by the ADA. And they are no longer illegally using drugs. Another type of person who is covered by the ADA are persons erroneously regarded as engaging in the illegal use of drugs. Let's move on to another set of questions. Number 7, does the ADA cover people with AIDS? And the answer is yes, the ADA covers people with AIDS and HIV disease from discrimination. Question number 8, can I consider health and safety in deciding whether to hire an applicant or retain an employee with a disability? The answer is yes. The ADA permits an employer to require that an individual not pose a direct threat to the health and safety of the individual or others in the workplace. A direct threat means a significant risk of substantial harm. You cannot refuse to hire or fire an individual because of a slightly increased risk or harm to himself or others. Nor can you do so on the basis of speculative or remote risk. The determination that an individual poses a direct threat must be done on a case-by-case basis and rely on objective, factual evidence regarding the individual's present ability to perform essential job functions. And if an applicant or employee with a disability does pose a direct threat to the health and safety of himself or others, still an employer must consider whether the risk can be eliminated or reduced to an acceptable level with a reasonable accommodation. We'll do one more question. Number 9. Does reasonable accommodation apply only to making changes in the employer's facilities? And the answer is no. Reasonable accommodation applies to all aspects of employment, including the interview process, training programs, even social activities that are sponsored by the employer. Now we're coming close to the end of our time here, and we'll continue this conversation in our next program. Now for today's programs, I've pulled a lot of information from the website of the Equal Employment Opportunity Commission, EEOC for short. On this website, you can find a wealth of pamphlets on Title I and the ADA, which you can read online or download. Now, today's key phrase is interactive process. I mentioned that briefly earlier. It's very important. If you remember only one thing from today's program, please remember interactive process, because the ADA stresses dialogue between the employer and the job applicant, and between the employer and the employee with a disability. I urge using this process not only for discussing reasonable accommodation, it is appropriate for all employment activities. Another key phrase is the email address, accessforall@yahoo.com. Use this address to send comments on the program and questions about the ADA. Now please keep your questions focused on the ADA. I won't answer questions about disability insurance, adaptive equipment, or your sister's medical condition. Until the next program, I wish all people with disabilities and those without good health, and let's all look to the day when the Pledge of Allegiance concludes with liberty, justice, and access for all.